Let's go to termination of employment. Since the right to security of tenure, even if it is guaranteed by the Constitution and the Labor Code, is not absolute, its limitation would be the valid exercise of prerogative to terminate employees. When we talk of termination of employment, we have to remember the two important components. The first component would be the substantive aspect, and the second would be the procedural aspect. When you talk of substantive aspect, we're talking here of the valid ground. It's either just or authorized cause. And this valid ground shall be supported by substantial evidence. A law student knows what substantial evidence, but for purposes of emphasis, in the case of Salvador versus Philippine Mining Services, substantial evidence is more than a mere scintilla of evidence or relevant evidence as a reasonable mind might accept as adequate to support a conclusion, even if other minds equally reasonable might conceivably opine otherwise. The decisions of the labor arbiter or quasi-judicial bodies should be supported by substantial evidence. And as you all know, that their appreciations of substantial evidence is respected in the appellate court unless there is grave abuse of discretion. In this case, the employer must believe with reasonable ground that the employee is responsible for the act alleged, and if it is a serious misconduct, the elements must be present, namely that the employee committed a serious act considered a serious misconduct, and the employee has become unfit to continue working. And the same is work related, and there is intent. So if the employer has a reasonable ground to believe that the employee committed a particular act, or in this case an act considered serious misconduct, and that would be substantial evidence as a basis, or evidence to be used as a basis in terminating an employee. The absence of substantial evidence will make the termination illegal, and there will be consequences such as reinstatement, back wages, or other damages as may be applicable. When you talk of procedural due process, we are talking here of the notice requirement. In addition to the substantial ground, you must comply with the procedural requirement, which means that you have to send notice to the employee. In the case of just causes, there are two notices. The first notice is the notice to explain why the employee should not be terminated, and the second notice will be the notice of termination. In the case of authorized causes, there is a twin notice. The first notice is sent to the employee 30 days prior to the effectivity of termination, and the other notice is sent to the dole 30 days prior to effectivity of termination, and they are sent simultaneously to be served personally. In addition, we have to remember the basic criteria laid down in the King of Kings Transport versus Santiago Mama, June 29, 2007. First, when you send a notice to explain, it must contain the specific acts committed, the facts and circumstances surrounding the commission of the act, the policy that is violated, if there's no policy, the provision of the labor code, and the employee must be given at least 5 days to answer. The ample opportunity here should be the opportunity or the opportunity given to the employee to explain his or her side, whether oral or in writing, in simple letter of explanation, or in form of affidavit. Hearing is not mandatory unless it is requested in writing with the employee, or where there is a company policy, or when, or policy or practice, or when the circumstances so warrant. The demand to pay is not considered notice to explain in the case of Summer Med Distribution versus NLRC, July 15, 2013. As well as confrontation before the barangay is not considered a demand to pay. In the barangay, the right to counsel is not available. In administrative hearing, the employee may bring his or her counsel to aid him or her in his or her defense. So therefore, the hearing before the barangay is not the same with administrative hearing conducted by the employer. As you can see, even in the labor court, hearing is not mandatory. Parties are only directed to submit the respective position papers, and thereafter the labor arbiter will render his or her ruling. In illegal dismissal case, we have to discuss also the burden of proof rule. Basically, the burden of proof rule requires that he who alleges must prove. So in this case, when you talk of illegal dismissal, we have to discuss who will prove that the dismissal is valid. But first and foremost, before we prove illegal dismissal, before the employer will prove the validity of dismissal, the employee must prove first the existence of employer-employee relationship, as what I have discussed in my previous discussion. In addition to that, the employee must also prove the fact of dismissal by substantial evidence. So when the employee has already done the burden, or is already satisfied the requirement of burden of proof as to the existence of employer-employee relationship and the fact of dismissal, then the burden of proof will swing now to the employer, and the employer will disprove and will present the evidence that there is valid dismissal, or the employer may prove that there is no employer-employee relationship. If the employer is successful, then the case will be dismissed. Now, the reason why in case of illegal dismissal, the burden of proof as to the validity of the dismissal rests on the employer, as well as payment of wages and other benefit, it is because the employer is in possession of all the records, payroll, payslip, an employee's 201 file, the employee may not have anything except a valid ID. The employee may not have a copy of the payroll or payslip. So all the employee will do would be to allege that he or she was not given the minimum wage and other benefit. Then it is now the employer who will prove as to the payment of wages and other benefits mandated by law, because the employer has the possession of all the documents. There are cases which require that the burden of proof doesn't necessarily mean should be satisfied with the employer. An instance would be the case of unfair labor practice. It is the union or the employee who felt aggrieved because of the alleged unfair labor practice has the burden of proof. In the case of Baptista et al. Versus Villanueva, January 31, 2013. In case of a practice or a policy that has ripened into a benefit, then it is the claimant who will prove, in this case the employee. When it comes to overtime pay, the employee has to prove that there was performance of overtime work. When it comes to early retirement benefit, then it is the employee who will prove that there is a policy granting overtime, early retirement. If it is voluntary retirement, then it is the obligation of the employee to prove that he or she is qualified under the CBA or under the rule that reaching the age of 60 is already voluntary retirement, subject to the 5-year of service. Since it is the employee who wants to avail of the benefit of this early retirement or voluntary retirement, it is but proper that the employee must prove that he or she is qualified to avail of early retirement or voluntary or optional retirement. If it is compulsory retirement, it would appear that the employee still wants to work with the company. The company has no other option but to terminate the services of the employee in the ground of compulsory retirement. Then it is the employer who will prove, based on the data available, birth certificate, more particularly showing that the employee has reached the age of 65. That's the burden of proof rule. So if you will be asked, discuss the burden of proof rule, you have to qualify. If it is burden of proof in case of illegal dismissal, burden of proof in case of non-payment of wages and other benefit, burden of proof in case of unfair labor practice. So you have to be very careful. If what is asked is only a simple question, a very generic question of what is the burden of proof rule, then you will presumably relate that to illegal dismissal case and non-payment of monetary benefit. Do not include those other requirements or other circumstances where the burden of proof will swing from one side to another, unless the question calls for that answer. So the mindset of the examiner when it comes to burden of proof rule would be illegal dismissal and non-payment of wages, and other benefits.